Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the federal and Florida M&A broker exemption. On January 31, 2014, the SEC Division of Trading and Markets issued a no-action letter in favor of entities affecting securities transactions in connection with the sale of equity control of private operating businesses, called an M&A broker. The SEC stated that it would not require broker-dealer registration for M&A brokers arranging for the sale of privately held businesses. The SEC M&A broker no-action letter specifically excludes transactions involving an Exchange Act reporting company. In addition, the SEC set forth the following limitations and restrictions. M&A brokers cannot bind third parties to a transaction. M&A brokers cannot directly or indirectly provide financing for M&A transactions. M&A brokers cannot have custody, control, or possession of, or otherwise handle funds or securities issued or exchanged in connection with an M&A transaction. No M&A transaction can involve a public offering. Any offering or sale of securities must be conducted in compliance with an applicable exemption from registration. No party to any M&A transaction may be a shell company. To the extent that M&A brokers represent both buyers and sellers, they must provide clear written representations as to whom they are representing and must obtain written consent from both parties for joint representation. If the M&A transaction involves a buyer group, the M&A broker may not be involved in forming the group. The buyer or group of buyers must control and actively operate the company or business and cannot be passive buyers. The buyers will be considered to have control if it has the power directly or indirectly to direct management or policies of the company, whether through ownership of securities, by contract, or otherwise. The necessary control will be presumed if, upon completion of the transaction, the buyer or group of buyers has the right to vote 25% or more of the securities, has the power to sell or direct the sale of 25% or more of the securities, or in the case of a limited partnership or LLC, has the right to receive upon dissolution or has contributed 25% or more of the capital. Any securities received by the buyer or M&A broker in the transaction will be restricted within the meaning of Rule 144, and the M&A broker, and if an entity, each officer, director, or employee of the M&A broker has not been barred from association with a broker-dealer by the SEC or any state or any self-regulatory organization, and is not suspended from association with a broker-dealer. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.